Good afternoon. This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please ensure that all mobile phones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the chair of the inquiry, Lord Justice Haddon-Cave, has made a restriction order dated the 5th of September 2024 in relation to the conduct of those who are attending the hearing. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The first part of the order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting, without the express permission of the chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. The second part of the order, which applies to the hearing scheduled to take place today and tomorrow, if the evidence is not concluded today, arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. Where those who have supplied evidence to the inquiry have applied to restrict information from publication outside of the inquiry, in some instances the chair has made restriction orders, the effect of which is to protect that information. A restriction order prohibits the use, publication or dissemination of the information that it covers. In the event that something is said during the course of this hearing which may breach a restriction order made by the chair, the evidence may be halted and the hearing and annex may be cleared for closed legal submissions as to whether any restriction order has been breached, and the live stream YouTube recording will temporarily be stopped for this period. Counsel to the inquiry or the solicitor to the inquiry must be informed of any request to make an application for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the chair has finally determined the application. Every restriction order is subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order.
Mr. Glasgow.
Please, you, sir. So, Ben, I hope that you had an opportunity over lunch to have a look at the letter that you had brought to our attention just before we rose for the short adjournment. It's not in the bundle, but you have a copy, sir, as do you and others. I provided a copy too. For those who are following in the exhibit references, it's MOD 198001587A. But we are in a position to bring a copy of the letter up onto the screen. So can I just pause, Sir Ben, whilst that happens? We see from the letter that you have a copy of, dated the 5th of April, headed Allegations of EJK by UKSF. So allegations of extrajudicial killing by UK Special Forces. And it's sent by N1785, the commanding officer, as was of UKSF 3, and sent to the attention of, as we can see, top left, the DSF. My apologies for not raising this with you during my leaving call, but I was still formulating my thoughts and our truncated meeting didn't seem the right moment. I have for some time been aware of rumours within UKSF-3 that UKSF-1 subunits have been conducting summary execution of supposed Taliban affiliates on target in Afghanistan. Until very recently, I've not reported this any further and cautioned my team against peddling malicious speculation. However, I have now been given more information of a nature which makes me seriously concerned for the reputation of UKSF. One of my team, an officer, has been told by an individual from UKSF-1 that there is in effect an unofficial policy amongst the UKSF-1 subunits to kill, wherever possible, fighting-age males on target, regardless of the immediate threat they pose to our troops. In some instances, this has involved the deliberate killing of individuals after they've been restrained by Subunit 1 and the subsequent fabrication of evidence to suggest a lawful killing in self-defence. And I'm pausing there for a moment. I will go on to look at the next few paragraphs, but can I ask you this, Sven? When you had sight of this for the first time, were you alarmed by what you read?
I was alarmed, yes. I mean, first of all, if you look at my evidence in my statement, you see the word revelation.
Yes.
In approximately October 2019. So I was alarmed. I was alarmed because of the author of it. But I also felt that at the same time it also aligned with my view. He was trying to do the same thing that many of us others was doing. It says clearly in his second paragraph, he started hearing rumours, and he was cautious not to effectively take them as substantive rumours. He saw them as rumours. But then further information appeared, and he said clearly doesn't amount to anything as substantial as evidence, but nevertheless he did the right thing and passed it up the chain of command. So I was concerned, but I also would refer you to the date. It was a decade before, nearly, or eight and a half years since my time. But nevertheless, it was an important piece of documentation that hadn't been originally given to me in any of the previous submissions.
Were you aware, Sir Ben, that the allegations as being made against UKSF were allegations of incidents at or around the date of this particular document?
Yes, because I mean, clearly the words around Northmoor. I mean the date around 2011. If you think the bracket for some of these incidences are quite wide. I think they go all the way up to 2013, 2014, and back to about 2000, before 2010 maybe. So obviously they cover a range of incidents. We often were talking about Northmoor specifically, but obviously there was Sestra and other inquiries. And if you think of it from a member of the military's point of view, they were all just operations. I think it was. I mean, it didn't specifically make me go, "Oh, that's Northmoor." It made me go, "There is some real concern from within inside that community about what's been going on." This individual, who I had the highest regard for, has referred it up the chain of command. But I think I was equally surprised, and it's reflected in my statement and the note from Damien Piamenta. That's my paragraph 24. That it sort of made me ask questions about it, and the recommendation was to make sure I ascertained whether Chief Constable Murphy was satisfied. So in that submission, it implies that he too had seen the letter.
When you looked at this particular letter, did you recognise that the allegations as being described in this letter from N1785 to N1802 were the same sort of allegations as were at that stage now being investigated as part of Op Northmoor?
Well, they were part of, if you remember at the time, there was Op Northmoor and Sestra, so there was more than just one group of allegations. So I think what it does was it links to the question about whether UKSF were engaged in a policy or indeed an individual was engaging in law breaking that was not in line with, obviously, our the rule of law and the Geneva Conventions, etc., etc. So it didn't make a big flag saying that must be the Northmore inquiry. That just raised a simple flag saying that is part of the more general, wider narrative about what's going on. And I think that was clearly part of what drove me to then obviously ask certain questions of Sir John Murphy.
So Ben, did you understand that Operation Northmore was investigating allegations of extrajudicial killings by UK Special Forces?
Yes.
Right. And you understood that those allegations came, of course, from Afghanistan?
Yes.
And you understood the complaints as raised by the BBC in their letter to you shortly before you looked at this, identified the suggestion, at least, that 52 killings had been investigated as part of Operation Northmore?
Yes.
Right. So, having been told that the allegations were broadly accurate, you then come across a letter from the commanding officer of UKSF3 to the DSF, sent at around the time that some of these allegations are said to have taken place. Would that be fair?
Yes. I mean, I didn't come across it. I requested it. Please make the difference between whether I deliberately was trying to get to the bottom of this or not, or whether I was wandering around accidentally finding documents. I requested this document. It wasn't automatically produced to me because I was seeking to find out, get to the bottom of where we were with both Northmore and indeed Sestra and any other allegations.
I didn't mean to suggest when I said came across it that in some way you'd stumbled over it. You've made it very clear, Sir Ben, that this was a document you had asked for after you identified it possibly in a footnote of another document. Now, what I'd like to ask you about this document is this, please. Knowing that Operation Northmore and the allegations are, according to DGEP, broadly accurate, and according to the RMP and its external governance, there's no evidence, and you've got those two positions which don't marry up. You now have a letter from an individual in the military whom you respect and rate and hold in high regard, and that individual has written to the DSF in 2011 to report, would it be fair to describe, very serious concerns to N1802?
Yes.
And now realising that there were serious concerns being reported at the time, did you make sure that you could understand all there was about this particular document?
I made sure that I asked the professional, Sir John Murphy, a man of extensive and deep experience in police investigations, that I made sure that he, who was the best placed to assess independently a number of these assurances, including the military police's investigation because he had access, that I made sure to seek his views and his advice, because that, as I have said, I am not the police investigator, I'm not a police officer, I don't have experience, to absolutely ascertain that this individual was either satisfied or not satisfied, and why he took the position he did in his subsequent report, the assurance of the investigation.
When you came to speak to N1785 himself, you told us that you wanted to know from him whether he was still, as at 2019, concerned about the allegations he had reported back in 2011.
No, what I said was I asked him if he was happy with the process we had followed since he'd sent the letter. He, like me, probably had no inside track to the police investigation. I had set out that we had done Chief Constable Murphy, Justice Lyons, and the other steps we were taking or had taken, and then also the courts that was ongoing at the time, and asked him if that satisfied that we were dealing with his concerns.
And was he satisfied that you were dealing with his concerns?
He said he was.
Did you seek to find out whether N1802 had done anything on receipt of the letter back in 2011?
Well, first of all, N1802 at that stage was no longer serving in the military, so I wasn't in a position to necessarily meet the individual. What had already, if you remember by then, I think in 2013 or 2014, the police investigation had started. So, in a sense, I then read the documentation around what N1802 had ordered, as a result of that letter, but it had not included a referral to the military police. So I was aware of what he did and didn't do. I didn't need to speak to him. I probably didn't have the authority to speak to him, but I was absolutely clear what he had done. And, you know, I can't talk in this court about the techniques, etc., but what he had instigated. And that had not included a referral to the police.
And as far as you were concerned, you made clear before lunch that if you had been in his position, you would have referred the matter to the service police.
Well, any serving member of the armed forces is legally obliged to do that under the Armed Forces Act. So, you know, nearly everyone I know would have done that.
As you told us, in due course, you went on to have a meeting with Sir John Murphy where this was discussed. And before we turn to that, I should do you the courtesy of just dealing with the last two paragraphs of the letter, which I said I would and I haven't yet read out. N1785 continued, what I've been told does not amount to anything as substantial as evidence. I'm sorry, I'll allow you to...
Yeah, no, it's fine, got it.
Thank you. What I've been told does not amount to anything as substantial as evidence, but to my sense it is more than just what had been until recently vacuous rumour. But if UKSF individuals are conducting EJKs, then the implications are clearly stark. Notwithstanding this, I feel most strongly that thorough, appropriate investigation is warranted. To be frank, I do not know what to do next, and to that end I'd welcome your assessment on how you think we should proceed. I'm sorry to have to bring this to you at what is already such a busy time. Rest assured I've only been aware of this issue for several days, not longer, that I feel I needed to pass on my concerns before I leave post as Commanding Officer UKSF 3 and before I assume command of SFHQA. Just pausing for a moment there, the first sentence of line 3, what I have been told does not amount to anything as substantial as evidence. Can we agree that if it is an accurate record in paragraph 2 of what he was told, it's certainly nothing like rumour, is it?
No, but I didn't say it was. I mean...
I'm seeking to understand...
Well, I set out that his letter recognises that his initial reports, in his view, were rumours, and then he heard some more information that he felt it made it stronger than rumour, but not substantial evidence. And so he then referred it up the chain of command.
And let's just consider that for a moment. An officer in his command has reported to him that a serving individual in UKSF 1 has admitted there is a policy of killing fighting-age males.
Yes.
So if we think about that for a moment, if one were to ask the name of the officer who has spoken to N1785 and one were to speak to that officer, you could ask that officer who had made the confession to him, and with that name you could approach an individual who might have first-hand evidence of a policy of murdering Afghan males on target.
So, two things. His letter actually says that there is, in effect, an unofficial policy.
Yep.
And secondly, this is, as I've said, a considerable number of years prior to me being in the chair, and in the meantime, a police investigation had started and allegedly had concluded. So, as I said earlier, it wasn't for me to go back on every point, given I had to take the view that the police had done their independent investigation, the service prosecuting authority, independent of me, had made choices not to prosecute or progress, certainly in Sestra, I think. And the options to me was to then go to the chief constable who independently assessed the quality of that investigation and interrogate him, because he had access to the full police investigation. I didn't in any way at all. And I would doubt that the author of this letter also had full disclosure of the police investigation, so wouldn't have been able to answer me all those questions. But I would have hoped, and I think they did, because Sir John Murphy had seen this letter, that he would have been asking the police, have they interviewed N1785? Have they elicited that information? Now, I don't know whether they interviewed N1785, because that is a matter of the police investigation.
it may be that you and I are at cross purposes, and that is entirely my fault and not yours. But if one puts yourself in the position of M1785 in 2011, he has a name of an officer under his command who has reported a very serious allegation. And in turn, he could provide the name of the person who had spoken to him. So it doesn't take many questions, does it, before you can actually get to the original source of the story that's being reported. Does that make sense?
That of course makes sense, but he took the path of referring it up the chain of command, right? Now, no doubt this inquiry will take a view that the Director of Special Forces, did he or did he not then follow the correct path in accordance with both the Armed Forces Act and elsewhere? But also, as the government has already conceded, we did not take timely action in 2011 or 10 to begin the investigation. We have conceded that already in court, and obviously that is the government's failing, and we made that clear. But having a police investigation started, I think in 2013, considerable time, 6 years before my post, I think it is right to assume that these would have been followed up, and I checked that with Chief Constable Murphy.
Well, again, you say right to assume these would have been followed up. Is that a safe assumption to make?
Well, it turned out that Chief Constable Murphy was aware of this letter, and as he was the one who had seen or spoken to the police investigation, I can only say that his conclusions are, stand with his professional reputation and his expertise, which I do not possess.
Can we just look then to that meeting, please? And I think I can help you in this regard. If you were to turn in the divider to divider number, so turn into the file to divider number 6. On the 30th of October, Damien Parmenter sent you a note in advance of your meeting with Sir John. And do you have that page 24 within our file?
Yes, do.
Operation Northmoor, meeting with Sir John Murphy, it's entitled. It's dated the 30th of October 2019. Secretary of State, you have a meeting with Sir John Murphy, former Chief Constable of Merseyside, one of the 2 independent panel members to the Northmoor investigation, brought in to provide independent assurance and advice to the process from 2016. Following the revelation of the letter, which is the letter we've just looked at, following the revelation of the letter and its author, you sought assurance on the credibility of the overall process and the individual's engagement with Northmoor. Can I pause for a moment and ask you this? Why did you need assurance on the credibility of the overall process? Why was it that this letter cast any doubt in your mind as to the credibility of the overall process?
Well, I think it relates not just to that letter. I think it also relates to the earlier letter you referred to, or the earlier submission from Ben Samuelson, about those questions that he said, some of these allegations are accurate. As I've said throughout, it's been an ongoing process. It's not just that one letter, and I'm not sure when I had asked to actually speak to Sir John. It was scheduled for October, but it may have been that my request to speak to him goes way back to that original paragraph 6 of the original August/September 29 submission asking me to close down the Defence Committee. So not close down the Defence Committee, send a letter to them. So I think it was always, as you can see, my intention to meet the Chief Constable of Merseyside because I wanted to get assurances. And ultimately, it's not just the last letter to DSF that matters. It was also, as you pointed out, that submission from Ben Samuelson, the earlier one, which we talked about.
Again, can we look, please, at the words of that paragraph? Following the revelation of the letter and its author, that is a reference to the one letter we've just looked at from N1785 to N1802.
Yes.
And the significance being the author, because the author of the letter was an officer that you held in high regard.
Yes.
So if Damien Parmenter is correct in what he has set out to you here, following the revelation of the letter from 1785 to N1802, and given it came from N1785, you sought assurance on the credibility of the overall process and the individual's engagement with Northmoor. So what was it about N1785's letter that caused you to doubt the credibility of Operation Northmoor?
So look, it is not one individual. I've been quite clear. It's not just his letter. As you rightly pointed out, the Ben Samuels submission raised concerns. The actual original submission, way back in August, about seeking my permission to send a letter to the Defence Committee, raised concerns. It was an ongoing concern I had. No one letter, like some smoking gun, may go, right, I'm going to ask Chief Constable Murphy. He was obviously very, very important to the process, going right back to that first letter, paragraph 6. He was the professional who could provide me the assurances about the quality of the police investigation. And if you remember, the judicial reviews were all about challenging whether the government acted in a timely manner, and under ECHR, was it, ECHR Article 2, I think, compliant quality of investigations. Those were the two main questions constantly being put to us as the government, and people like Chief Constable are very, very important in us giving me and my predecessor the answer of was this Article 2 compliant? Was it of a right quality? And he is the expert, not me. So I'm afraid it wasn't one simple submission that triggered it. As I've shown from the very outset in August 2019, I took a view there was more to get to the bottom of it, and I continue to do so. Of course, the former this letter gave weight because it came from another angle, and it wasn't something that had been voluntarily offered up to me, which raised my suspicions further in the process of the system. But if there was never a space between me taking office and the meeting with Chief Constable Murphy where I didn't have a determination to satisfy myself about the quality of these investigations. And when I said earlier I had been the Northern Ireland Minister, I had seen endless legacy investigations opened, some successfully, based on a failure by the state to investigate properly. So I understood the ECHR vulnerabilities that we face if we don't get this right.
If one accepts the letter at face value, back in April of 2011, a respected senior officer within UKSF was reporting to the Director of Special Forces, at the very least, the possibility that UKSF-1 were murdering people in Afghanistan.
Yes.
So that, given it was April of 2011, might be sufficient to trigger an investigation into what was going on?
Well, I think there was an investigation eventually in 2013 by the police.
That was in relation to Operation Sestro.
Well, when did I mean, Northmoor started before my tenure, right? So this letter triggered 2 police investigations, or 1 at least, before my instigation. There was a police investigation, before my time and when I took over. So if your question is, was it important enough to trigger another police investigation by another police force? That's a different question. Or is it that the police investigation, which had been assured by Chief Constable, was, I mean, what I would like to know, if Mr. Glasgow, you may say it's not your job to tell me, but the options available to me, going back to the August 2019 submission, was to satisfy myself of the quality and the assurance of the police investigation. How that police investigation started, when it started and how, is actually a matter for my predecessors, or indeed the Provost Marshal, when it started. But ultimately, there isn't much in this letter I didn't disagree with, but in the intervening 6.5 years, a police investigation had taken place, if I'm not correct. And I am not a police officer, and I'm not an expert in police investigations, but I knew a man who did, and that was the Chief Constable Murphy, who I was due to have a meeting with in October.
One of the allegations, as you identified from the JR, was an issue as to the timeliness of the investigation into the allegations. And you now have available for you a letter in April 2011 which identifies to the attention of the Director of Special Forces very serious allegations of potential murder being committed by UKSF1. Did you think to yourself that might have been the starting point or the appropriate starting point for an investigation? April 2011.
I'm sorry, it's totally immaterial. Someone had already made that decision and there had been a police investigation. I mean, I'm not able to direct police investigations. Secretaries of State, whether you're a Home Secretary or a Defence Secretary, we don't... the independence of the police is paramount. We don't direct them to investigate. There had been, in the intervening 6.5 years from this letter, 2 or 1 at least police investigation. I'm not sure what you expect me to be doing. I sought the professional opinion of a Chief Constable of Merseyside with, I don't know, 30, 40 years of experience. And I don't know what you're now expecting me to say. I mean, I wasn't there in 2011.
I've not suggested you were, Sir Ben. What I'm asking is, given at this stage there was an issue as to the timeliness of investigations conducted into the allegations, which was being disputed in the judicial review proceedings, when you saw this, did you think to yourself, that really ought to have been the starting point for an investigation, April 2011?
Yes, it should have been. And
Thank you.
But because one then did happen some years before my tenure...
Some years after that letter?
I'm not responsible for something before my tenure, Mr. Glasgow. Or would you like me to pretend I was the Secretary of State in 2013?
Well, that would be a silly exercise.
Well, then you keep bringing me back as if I received the letter in 2011 or 2012 and asked questions about why wasn't there a police investigation, when, of course, there was a police investigation 5 years before my tenure. So, in a sense, the only question for me was to ascertain whether that investigation was properly carried out in a professional manner and covered the whole scope of the fears and the allegations put to it.
And how about whether it was carried out in a timely fashion?
Well, we conceded it wasn't.
Only after documents came to light which demonstrated you were mistaken in that assertion, Sir Ben. That's why I'm...
Well, I don't know when the actual date when we conceded to the judicial review that it wasn't timely. If you were to give me that date, that would help me navigate my way through the process. But from the day I first received that August/September submission in 2019, I sought consistently to get to the bottom of the investigation and find out the quality, etc., of doing it. I am not responsible for the lack of timeliness between 2011 and when the police investigation started.
I believe from recollection, I think it was the 4th of March of 2020 when matters needed to be corrected, but I'll check that. And if I need to give you another date, of course, I will do so, Sir Ben. Can we just go back to where we were, please? Your exhibit number 6 and the letter that was sent to you by Damien Parmenter about your upcoming meeting with Sir John Murphy. We were in paragraph 2. We had dealt with the first sentence. Can we look at the second sentence, please? Sir John had spoken to the author, and it was felt Sir John was best placed to provide you with an independent view of the investigation and his perspective on the author's accusations. So if that's a correct assertion of what was to happen, does it seem that you wanted to speak to Sir John Murphy not only about the letter itself that you read, but also about the author and his perspective, Sir John's perspective on the accusations?
I had wanted to speak to Sir John Murphy since I read paragraph 6 of the submission back in August 2019, because he was the very important part of the assurance of this investigation. The letter came to light after I had asked to speak to him, so of course it was important to include that in any discussion I had with Sir John to find out had he seen it, and indeed Damien Parmenter, who was then my principal private secretary at the time, said obviously in that note that he had, and therefore could that be included in the discussions, because that is, I think, obviously quite important, because as he was holding the police or looking at the military police's investigation, then of course if he knew of this letter and the content, then he'd be able to ask the questions you've just asked me, Mr. Glasgow, all those times ago.
And presumably you did ask him the same sort of questions that I've just asked you.
Yes, I did.
So
the focus I had was how good was their investigation, was it up to a good quality? Was it correct for them to say that there were no evidence, not sufficient evidence, I think, to charge? Was that appropriate? Those were the questions I asked him in my office.
And this was the meeting you had with him on the 31st of October between 11 o'clock and 11:30 in the morning?
Yes. Yeah.
And that you'd identified in your paragraph 25 at the bottom of page 8, if it helps.
Yes.
When it came to meeting with Sir John, did you discuss with him in terms the letter that you had been shown perhaps 3 days before? The letter from N1785?
Yes, I discussed that and indeed the broader, I suppose, state of play where we were.
Did you ask him whether N1785 had been spoken to by him or by anyone else in the investigation?
If my memory serves me right, and there aren't, I don't think I have any notes of this, but I'd asked him if they had, if his was understanding that the investigators had spoken to them.
Right. And why aren't there any notes of your meeting with Sir John Murphy, please?
I don't know.
Right. Would you expect there to have been notes?
Yes, I would have expected me to be there.
Right.
Yeah, I mean, I think it's in my own, at its heart, because I'd been the security minister with investigatory powers and understanding what powers are available, especially in national security spaces. I asked him very much about, was it right to say that Northmore and other investigations should be closed? How much, how good or what did you think of the investigation? And was it correct? There wasn't sufficient evidence.
Can we just look back, please, to the email or note that had been sent to you by Damien Parmenter?
Yeah.
You probably still have it open, page 24.
Yeah.
And that middle paragraph, second sentence, Sir John had spoken to the author. Now, if that is a correct description of the information provided to Damien Parmenter, it's to the effect that Sir John Murphy had spoken to N1785. So it's not a case that, as you just said, Sir Ben, that the investigators had spoken to him.
Yeah. Well, I'm not going to... I can't remember the full details of the meeting. So, okay, I won't speculate the line by line of that meeting because, again, I don't have the notes and nor does anyone else, regretfully. But fundamentally, I tested him on what he thought about the authenticity and the quality of the investigation. And I think I said I would hope he would have spoken to him.
Why would it be appropriate for somebody giving oversight and assurance to an investigation to speak to an individual witness? Shouldn't that be the job of the investigators?
Well, I think if Chief Constable Murphy, I mean, some of this Chief Constable Murphy is going to have to answer about how he conducted his independent... Do you mean him or me doing oversight?
No, you've just said, Sir Ben, that you would have hoped that he, Sir John Murphy, would have spoken to N1785. Yeah. And I'm asking you why you think it would be appropriate for somebody giving quality assurance to an investigation to actually start speaking to individual witnesses and becoming themselves an investigator.
Well, his assurance, unlike mine, was about the professional and the expertise of police investigation. If, and only he can answer, if either he felt that he didn't know or the RMP didn't tell him, I mean, this is all speculation, whether they had or hadn't spoken to N1785, then he would have probably tried to find out if that was the case. I don't know. This is the realms for him, I think, to answer. But ultimately, if he was giving assurance, his job and his powers was to actually look right inside the police investigation in a way that preserved their independence away from the political leadership of the department.
Can you remember now whether Sir John Murphy told you if he had spoken to N1785?
I can't remember if he did, but the note from Damien Parmenter alludes to the fact he did say that.
You said in your witness statement that you were interested in the progress and outcome of the serious and lengthy investigation. The conduct and the direction of the investigation was for the investigators alone to determine. If it helps you, you'll find that as the last sentence of your paragraph 25, about a third of the way down page 9.
Yeah.
If the conduct and direction of the investigation was for the investigators alone to determine, why would Sir John Murphy, who was providing quality assurance to the investigation, start conducting inquiries directly with a potential witness?
It is for Sir John Murphy to answer how and what methods he uses to assure a police investigation. I don't know. I don't know whether it's a good or bad idea. It is for a professional police officer to answer those questions.
Well,
I mean, does he consider that investigating, or did he consider that verification of claims made by the RMP? I don't know.
The reason I ask it is because you have said you thought it would have been a good idea for him to speak to N1785. Why would it be a good idea for him to do that, Sir Ben?
Well, because I think part of assurance is verification. You know, I tried and verified that what I was told was correct in my submissions. I would try and verify that, you know, a number of the things that I had asked for had been followed up. So I suspect it's a matter of opinion whether independent assurance includes verification of the functions of the RMP or taking it at face value. And one of the ways you can verify is cross-checking a witness.
Would you expect him to have cross-checked with other witnesses?
I am not qualified as a professional police investigator to answer that question.
With respect to Ben, you did just offer that opinion a moment ago with regards to N1785, which is why I'm asking again if there are any other witnesses that you think...
Well, I don't know all the witnesses in the investigation of the RMP investigation because I'm not the military police. What I do know was this letter was sent and you know, I got the letter on request, and then in that space, this is a significant individual who therefore had raised a point. I mean, that's the position, but the position of how you, as a professional or an expert, verify and assure the work of another police force or police officer is a matter for that person. All I can do is have a conversation with him and ask him if he was satisfied with the evidence produced or not.
Did you ask him if he'd spoken to any other witnesses apart from N1785?
No.
Did you ask him whether he carried out any other investigations himself?
Well, you can categorise an investigation if you want him speaking to N1785, but as I've said, it could be a verification, and I think some of these questions are actually best pointed at Chief Constable Murphy. What I asked him was he satisfied? What did he have concerns about in the police investigation? And was it correct to say that they couldn't progress because they had insufficient evidence? And it was at that stage he said to me, it wasn't that they didn't have insufficient evidence. He said, I found they had no evidence.
None at all?
That is the words he used.
So what? I found they had no evidence.
We were talking about a report, third hand, that had been told to me about an investigative technique that the military police wanted to use, and that requires a legal threshold. And as I was the minister oversighting, had previously been the minister oversighting Investigatory Powers Act, I knew that those thresholds required certain safeguards and indeed activities. And in that discussion, I said, did they do this and did they try and do it? And he said they had absolutely no evidence at all to make it to that bar to carry out that type of investigative level. And that's when I said, is it correct that they said they didn't have sufficient evidence? And he said, sufficient evidence, they didn't have any.
Right. So it's not a case of not quite getting to the bar, it's a case that it almost didn't get off the ground at all. Well,
I know you're a criminal barrister, Mr. Glasgow. You'll know that when it comes to investigatory powers, you have to have certain grounds beyond in a sense, normal, intrusive or non-intrusive surveillance techniques. And so I think that was the area we were discussing, first of all. And when he discounted that, and I can't say in this open court what had been considered, I then asked him about the overall assurance he had.
Did you say to him that only last week I received a letter from DGEP in which they informed me that many of the allegations are broadly accurate?
I didn't inform them specifically to that submission.
Well, did you say I have been advised by my department?
Yes. I said that, but I think, there's no notes to the meeting, so I can't remember it all in detail, but I had the meeting because I was concerned. I tested the veracity of certain statements about the quality of an investigation, and at the same time, even after this meeting, I carried on testing the statements made to me in submissions.
After your meeting with Sir John Murphy, in which he told you that there was no evidence, did you then speak to anyone from DGEP? For example, Ben Sanders, who sent you the document that we looked at in divider number 5, to question how it was that the department's detailed examination had led to a conclusion the allegations were broadly accurate, when Sir John Murphy had told you there was...
Well, there was no... From Ben Saunders's letter, a submission, there was no significant follow-up with the details of the allegations that were viewed to be accurate. However, what did happen was that Ben Sanders was tasked at a time, and I think it was towards the end of the year, to absolutely go into finding whatever documentation was available. I was getting fed up with DGEP coming to me and saying, I'm not sure, as they did later in the following year, conceding that there were documents that they hadn't seen, and now they would have to deliver them to the JR, which I felt made us all look stupid, including the ministers who'd been given assurances previously.
Following the meeting that you had with Sir John on the 31st, the next, not a document that I can help you with, but an entry in your witness statement, if you wouldn't mind, please, Sir Ben, to look to page 9, if you're still there, to paragraph 27.
Yeah.
Was the response that was provided to Panorama, which you ultimately approved as you've described it.
Yeah.
We reject the substantiated allegations of a pattern of cover-ups. Your allegations relating to General Sir Mark Carlton-Smith are untrue. No consultation, meeting or conversation took place between Sir Mark or the previous Director of Special Forces and David Cameron on the subject of investigations or night raids. Our military served with great courage and professionalism in Iraq and Afghanistan, and we hold them to the highest standards. It is government policy that military operations are conducted in accordance with the law of armed conflict, and where allegations are raised, they are investigated. The service police have carried out extensive investigations into allegations about the conduct of UK forces in Iraq and Afghanistan. After careful consideration of the referred cases, the Independent Service Prosecuting Authority decided not to prosecute. Investigations and decisions to prosecute are rightly independent from the MOD and have involved external oversight and legal advice. The BBC's claims have been passed to the Service Police and the Service Prosecuting Authority, who remain open to considering allegations. Can I ask you this? Before you ultimately approved that wording, did you have any further discussions with DGEP to satisfy yourself about what they meant when they said the allegations were broadly accurate?
I can't remember.
Would you like to think you would have inquired into that assertion before a letter was sent to the BBC indicating that everything had been investigated and there was nothing to prosecute?
Well, I think what I did was I reflected that the Independent Service Prosecuting Authority decided not to prosecute. Again, not something I was not in, and nor should I be, in complete possession of all the information the Service Prosecuting Authority had when it made that decision. I reiterated the position of the Service Prosecuting Authority in that statement, and I reiterated that we have passed the claims to the Service Police and Prosecuting Authorities, which I think is the right thing to do. And I had also, as you know, I'd been in contact with the BBC asking them to forward any evidence they had to the prosecutor and the police, or the police actually, rather than the prosecutor. So I reiterated that. It doesn't mean to say by issuing that, I didn't say anywhere nothing further, you know, there will be no more investigations or anything else. I stated where we were at that moment. And I carried on, as you'll know from my statement, seeking verification assurance around some of the claims throughout my tenure, including the full motion video.
And if I've understood your evidence, where you were at that moment was that you had spoken to Sir John Murphy, who had assured you there was no evidence.
Yes.
Which meant that the decision by the SPA, the Service Prosecuting Authority, not to prosecute was backed up by Sir John Murphy's assurance.
Sir John Murphy assured the police investigation, not the prosecutorial decisions of the SPA. And I'm not sure it's the same as CPS. I'm not sure who independently oversights CPS or SPA decisions in our system. But in the police, he was looking at the police investigation.
Again, my fault entirely. The position in which you found yourself was that Sir John Murphy had reassured you that there was no evidence identified by the Service Police investigation. Yes?
To date, yes.
That sat well with a decision by the Service Prosecuting Authority not to prosecute anyone, because you were told there was no evidence on which to do so. Yes?
Well, it was one plank of the work I was trying to do to verify how much the quality of the investigation and the allegations that were being made, and more allegations were being made. Again, from the media side, more allegations were coming to light. This was not static. I think this is if you look at the different programs of BBC and Sunday Times, new revelations or new allegations were being made. So this was always a moving narrative or a moving challenge for both me, department, no doubt the military police, and indeed the journalists. So I think the point was, at that moment in time, the SPA had said there was no case to prosecute. I'd had my meeting with Sir John Murphy, who had been he wasn't very positive about what he viewed as the professionalism of the military police investigation, but he did satisfy himself. He said to me that there wasn't evidence of the enough or any evidence, as he said, because I asked him whether that was the right also phrase to be using in the lines of the department. You know, there's not sufficient evidence to charge. So, but I cannot tell you what went on inside the Service Prosecution Authority, and you may be able to correct me on this. In some cases, there was a referral to the SPA, but in other cases, there were not.
That's correct, sir.
That's correct.
You've just mentioned that Sir John Murphy told you that he was not satisfied with the professionalism of the investigation.
I think that was around the surveillance techniques that I've been talking about.
Right. Did that have any impact on his overall conclusion that nonetheless there was no evidence?
Well, he maintained that position.
Did you challenge him on that at all?
I challenged him within my competence. I mean, I challenged him insofar as, you know, there's a person who spent 30, 40 years in the police, and that was his assertion. I was always keen to make sure that he had as much availability of openness and everything else, you know, while the military police, did you get full access? And he didn't say he didn't. He wasn't negative at all. So I took him at what he said.
Can we just look again in your statement on to paragraph 28 together for a moment, please? Takes us to mid-November of 2019. The Sunday Times indicated that it was planning to publish further allegations linked to Operation Northmoor. I approve the following MOD statement. Allegations that the MOD interfered with investigations or prosecution decisions relating to the conduct of UK forces in Iraq and Afghanistan are untrue. Throughout the process, the decisions of prosecutors and the investigators have been independent of the MOD and involved external oversight and legal advice. Cases were referred to the Service Prosecuting Authority as a result of investigations in both Iraq and Afghanistan. Cases from Iraq were referred as a result of historic investigations. It's untrue to claim cases investigated under Operation Northmoor in Afghanistan were not acted upon. After careful investigation overseen by a former Chief Constable, no Northmoor cases were referred to prosecutors. The Service Police have carried out extensive investigations into allegations about the conduct of UK forces in both Iraq and Afghanistan. The Independent Service Prosecuting Authority decided not to prosecute any of the cases referred to it. Our military served with great courage and professionalism in Iraq and Afghanistan, and we hold them to the highest standards. It is government policy that military operations are conducted in accordance with the law of armed conflict, and where allegations are raised, they are investigated. The Sunday Times' claims have been passed to the Service Police and the Service Prosecuting Authority, who remain open to considering allegations. So as we see the sign-off at the end of that statement, similar to the one before in response to the BBC, that the Service Police have been passed the complaints and the Service Prosecuting Authority remain open to considering allegations. And does that echo what you had said before, that the investigation is never closed?
Yes, I mean, I think that reaffirms that far from the initial application of submission, that any new evidence would be considered by both the Service Police and the Service Prosecuting Authority. And I think here, what is also important, which is often a recurring theme in media comments on military justice, is the sense or the implication that we interfere with independent police and service prosecution decisions. That is often muted or explicit in some cases in media, that ministers or people in the department interfere with that. And I am very determined that that is not the case. I was determined to make sure that they always remained independent, and we can always do something about improving the quality of any police investigation and the assets at their disposal, but fundamentally it was important to make that clear. No minister arrived in my department when I was there. I didn't interfere. I was really cautious even when to meet senior military police, just as it's a good idea for MPs and the judiciary not to mix.
Can we just look together at the second paragraph for a moment? Can we look to line 3 together? It is untrue to claim cases investigated under Operation Northmoor in Afghanistan were not acted upon. Can I ask you this, please, Sir Ben? When that was approved by you, did you take account of the fact that you knew that N1802 had not acted on the complaint brought to his attention by N1785 in April 2011?
Yes, but that was clearly corrected some years later when a police investigation started on those allegations.
Well, in fact, it's true that they weren't acted on in a particularly expeditious manner, but eventually somebody got round to looking at it. Is that what you mean?
I don't think the police investigation, I think you'd be pretty unreasonable to describe it as getting round to looking at it.
Well, in terms of getting
carried out a proper police investigation independently assured by a chief constable. Now, we may not think it produced the results, or it may not be good enough, but it wasn't quite like getting round to doing it. There was a police investigation. It could have been quicker from the 2011 memos sent from that individual to DSF. It could have been much quicker, but that was long before my time. But by the time I had got my feet under the desk, there was a police investigation into it, Mr. Glasgow.
Actually, if what you've told us is correct in respect to the April 2011 position, as you understand it to be, the Director of Special Forces did not act upon the complaint that was brought to his attention by M1785.
He did not act in accordance, in my understanding of the Armed Forces Act, but subsequently it was acted upon by the military police, and a police investigation started before my time, by some considerable time before my time as Defence Secretary. So in the end, there was a police investigation, and yes, it could have been timely, which we conceded, but it was definitely before my time as Defence Secretary.
Can we look, please, with your help, in your statement to page 14, Sir Ben? And I'd like to look here, please, to the allegations that surfaced in August of 2020 about the position that had been taken by the MOD on the 4th of March of 2020. You may remember that's the date I referred you to a little earlier this afternoon. And if it helps you to find your position,
yes.
Please start, if you'd like to, page before, bottom of page 13.
Yes.
So some 4 months or so after you had seen the letter from N1785 to N1802, the MOD on the 4th of March took a position in the judicial review proceedings which had to be withdrawn from.
Yes.
And that was the claim that matters had been investigated, sorry, that the complaints had not been made at the time of the allegations. Do you recall that?
Yeah.
So, in other words, actually, if anyone had had an eye to the letter from N1785 to N1802, no one could have said that corporately the MOD were not aware of allegations being made.
In
2011.
I'm not sure how far wide at first that went from the letter to DSF. But very soon, I think it became wider known either in the chat or the rumour mill, the broader community, that these were allegations or concerns. And what I don't know is the actual start date of the police investigation. It would be useful to have that. But ultimately, I think when 2020 happened, in March 2020, I think that having discovered, maybe might be the wrong word, or seen further documents, the team that was trying to defend timely and quality investigation recognised that they couldn't maintain that defence of timely, and therefore conceded that it should have started earlier. Now, what I don't know is what the position would have been, or how debatable should have started earlier meant. I mean, is timely set out in statute, or is it, I don't think it is, but roughly, I don't know what existing case law shows what a timely investigation should be.
When you agreed to the position being withdrawn, because the defence was filed in your name, but when you agreed to it being withdrawn, did you have in the back of your mind any recollection of what you'd seen 4 months before, namely a letter from a respected commanding officer of UKSF3 to the DSF reporting his N1785's concerns?
Yes, I mean, I think by the time we got to 4th of March, or about that time, I think me and Johnny Mercer probably lost our patience with the assurances we'd been given. And that is about that time that Ben Sanders, we said, go through every single thing again. Go through all these papers that you've discovered, you said you knew about, and we need to get a full understanding. We don't want any more papers popping up as a surprise, because it wasn't just the court that knew that these papers had appeared, it was the ministers as well. So I wasn't aware, the papers that went to the court, we weren't aware of as ministers either. I don't know when the exact date that DGEP said, oh look, here are these papers. I don't know when they internally discovered it, but I do know after that we got to a stage where we said we shouldn't be having any surprises. We don't want any more surprises. This is undermining the case. Go away and see it. And Ben Sanders was allocated that role. And he spent a lot of months. I mean, it took him a long time.
So it was his task at your direction to go through all the paperwork with a fine-tooth comb to make sure there were no more surprises.
Yes.
You'd asked about the start date for Operation Northmoor. It was directed by Provost Marshal Army in March of 2014.
Okay. So
almost 3 years after the letter had been sent by N1785 to N1802.
Thank you.
The position that was withdrawn from became the subject of press reporting in the Sunday Times on the 2nd of August of that year.
Yes.
And documents which had been disclosed as part of the judicial review proceedings featured in the article in the Sunday Times itself.
Yes, they did.
And in respect of that article, one of the criticisms or allegations that was made was that the MOD had withheld relevant documentary evidence, including emails.
That was one of the allegations, yes.
You record in your witness statement that this was the first time that you were made aware of any allegation that the MOD had knowingly withheld relevant information from disclosure.
Yes.
Prior to the article coming out, you must have been aware that at least there had been an oversight as to the existence of that material.
We knew by experience that once we handed these documents over to the court, it wouldn't be long, well, not just the court and various parties, it wouldn't be long before they would appear in the media. So, of course, we knew it would sadly appear in the media, but nevertheless, I knew what was going to the court, and that was just the reality of it. And it was in those bundles that I read in detail the emails of emails, the much broader discussions within SF and the community about what was going on.
Aside from the allegation appearing in black and white that the MOD was said to have deliberately withheld relevant documents.
Well, I didn't say I necessarily agreed with that.
I didn't say that you did.
Okay,
aside from the allegation appearing in black and white that the MOD had deliberately withheld documents, you at least knew before you read that article that there were documents in existence which had now had to be handed into the judicial review proceedings, and the MOD had had to withdraw its position that it had taken in March.
Yeah.
So whether it was phrased by the Sunday Times in an overtly critical or unfair manner, if we just put that to one side for a moment, I'm not going to ask your opinion as to that piece of journalism, but just this. What, in terms of what appeared in the paper, the documents and the facts that they hadn't been handed over, that came as no surprise to you.
Unfortunately, it became more and more apparent that we were learning almost every few months of some document or something or other that was coming out. Some of that was through the press reports, and some of that was then by DGEP and others doing more and more discovery. I think, I don't know what exactly it was that the legal representation of the MOD representatives made them decide that they should concede timeliness. I don't know what it was. Certainly what I could say from the documents I read, it certainly demonstrated in the documents I had read that a lot of people had a lot of concerns within the actual community of the SF at those times. And therefore there was clearly no excuse for either the commanding officer or indeed Director of Special Forces to have referred that in any way to the police.
So your
no excuse not to refer it.
As in they had no, I think when I read the emails, often between people who weren't there, so we're not talking about sort of material witnesses, but there was clearly a weight of concern that meant that the position of not referring it from DSF was not defendable.
And the
which subsequently it wasn't.
And you also referred to the commanding officer not referring it.
Well, the two main people responsible would have been the immediate commander. I mean, anyone is actually responsible under the Armed Forces Act, but the commander of the subunit, as they call it, the commander of the unit, and his overall commander, DSF, all of those would have had a direct responsibility for for making a complaint to the military police or a report.
Would you expect officers within UKSF who have the appropriate integrity and moral courage to call this sort of behaviour out?
Yes, and they do.
And would you expect people who are made aware of very serious allegations to ensure that those allegations are investigated?
Yes. And it's not just SF.
No.
Obligation of anyone in uniform.
The moral courage element is one of the essential qualities that's expected of anyone who wears a uniform and serves. And
why we are supposed to be better than our enemy.
The courage to do the right thing even when it is difficult to do it.
Yeah.
And the courage to speak out even when everyone else is saying something different.
Yes.
So I'm mindful of the time. I know that I've been busy with Sir Ben now for just nearly an hour and 10 minutes. Would now be a convenient moment for a break. And I will make sure that I can conclude my questioning this afternoon.
Thank you. Thank you, Mr. Glasgow. We'll break, please, until past.
Could I ask for 25 past?
You can ask for 25 past.
The difference, thank you.
And perhaps the doors and windows might be opened to cool the place down. If anybody wants to take their jackets off, they should feel free. 25 past, please. Thank you. Mr. Glasgow.
Please, sir. So, Ben, following the article that appeared in the Sunday Times on the 2nd of August 2020, you requested a meeting which took place on the 5th of August. To help you with that, can I invite you to turn to your Exhibit 11, which is behind tab 11. And for those who don't have a tab bundle, it's page 50. The meeting that took place included, amongst others, Johnny Mercer and a number of other officials. I'm so sorry, I'll let you find your place. Divider 11, page 50.
Got it.
Thank you. The meeting on the 5th of August, which was entitled Op Northmore Meeting in the notes that you've kindly provided to us, was attended by you as well as by Johnny Mercer and other officials and legal advisors. Can I ask you this? Prior to the meeting on the 5th of August, do you remember now whether or not you and Mr. Mercer spoke on the telephone to discuss the article that had appeared on the 2nd of August?
I do remember. I can't remember what we said, but it was one of the motivations why I was determined to have this meeting. And I think I asked Johnny Mercer, I think was down in the southwest of England, and I was determined that we had as many of the key people at the meeting as possible.
In terms of the discussion that you and he had, what, if anything, were his concerns that he voiced to you about the article in the Sunday Times?
I think it was that we were just not being told what we were asking for by the department.
And was that a concern that you now shared with him?
Yes, I mean, it's not quite a now. Right from the start, I would have, these things, every time you tested, you were getting more back, such as the letter to DSF. But also, I think it was absolutely the case that there's enough of this. We're going to. It's quite hard when you completely lose all patience with. You can shout and scream all you like, but in the end, you have to get to resolve it.
In terms of the shouting and screaming, can we just look at the clarification that you insisted on being provided? We can see the key points are set out in paragraph 2, and you sought clarification on 2 points raised by the media over the weekend: the reported requirement for you to give evidence to the court, and the assertion that the MOD had knowingly withheld information from the courts. And did it come to pass during the course of this meeting that you were assured, first, that you did not need to give a witness statement?
Yes, I mean, I think the sort of way the article was written, I was about to be summoned into the middle of the court to answer the JR, as opposed to the department, effectively.
So, albeit it had been described in the reporting that you would be expected
Yes.
to give evidence, in fact it was that the department, not you personally, would be expected to make a witness statement.
Yep.
And that was a witness statement due to be made in September. If it helps, we can see that, page 52, paragraph 10. Five lines up from the bottom on the right-hand side, officials confirmed that the next steps were for the department, not Secretary of State personally, to make a witness statement in September.
Yep.
Can I just ask for your help about some of the matters raised in the note itself? Would you mind if I did so? Could I ask you, please, to turn back to page 51 to paragraph 6, Sir Ben?
So I'm just finishing paragraph 2.
Of course.
Okay, sorry, paragraph 6.
Paragraph 6 on page 51. Secretary of State was concerned that ministers were unaware of the intended release of information. And by that, was that release of information to the media?
I think it was the actual moment it would go to the court. I think
Right.
Once it was out of our hands, it was hopefully within the court, but sometimes they didn't happen. So.
Right, because as we can then see, officials confirmed that this was an error of judgment, in other words, an error on their part. They had not expected the information to be provided to the media.
Yeah.
And then to pick up on some of the things you've already told us, paragraph 7, if we can, together, please. Secretary of State asked for assurances that MOD officials working on the judicial review have or will have sight of the totality of information available as part of the Royal Military Police investigation to assure themselves they are fully informed.
Yes.
And is that what you expected, that they would be given access to everything in order that they, MOD officials, could make an assessment of what had gone on?
Yes.
And is this, in part, the process that Ben Sanders embarked upon
Yes.
the course of many months, where he went through a vast amount of material?
Yeah.
And then if we look to the last 3 lines of that paragraph, number 7, Secretary of State instructed that DGEP ensure that all appropriate resources were obtained and deployed to ensure no repetition of errors and to assure the department's effective conduct of the judicial reviews in all respects.
Yes.
And is that bluntly what you expected, that no matter what it cost, the department would ensure that no more mistakes were made?
Yes, it was. And to allocate the resources. I mean, what often happens in a department is almost no civil servant will tell you they don't have enough people working on it. They never tell you, partly because that means they upset the Perm Sec rather than the minister. So the language is always a bit circular about, they'll say, yes, Secretary of State, they'll disappear. And when you ask why it hasn't been done, they don't say, well, there's only me and a dog doing it and no one else. It's always, it's quite hard to ascertain whether money has followed your intent. Of course, money is finite, so let's also be honest there. But yes, ultimately, in the end, you have to rattle that cage a bit more.
And in terms of rattling the cage, can we look, please, with your help, back to page 52 and this time to paragraph 11? The Secretary of State asked for officials to share the witness statement with ministers by the 1st of September and directed that those in the judicial review assure themselves that they have reviewed all evidence available by the October deadline and understand the implications of it for further disclosures to the court.
Yeah.
So if it wasn't already obvious in what you'd said before in this meeting, spelt out loud and clear your expectation that everyone would need to assure themselves and make no more mistakes in future.
Yes.
Can we just look lastly to what's entitled political narrative? You'll find that paragraph 17 and 18 on page 53. Min DPV, that's Mr. Mercer, spoke on the political narrative and notably the link to the Overseas Operations Legal Protections Bill. He was concerned that his January statement to the House of Commons may have been incorrect. If he was found to have misled the House, there would be a potential knock-on impact in political confidence. He asked that everything is shared with ministers who can then make a judgment of whether it's relevant or not politically. Officials observed that they did not consider the statement to be misleading, but agreed to review it and identify if there were any inaccuracies, and if so, how they had arisen and how they might be rectified. Can I ask you this, please, about that paragraph, Sir Ben? Was this something of particular concern to Mr. Mercer?
It was, and for the inquiry's information, this was a statement he made on the 7th of January 2020 in a German debate in the House of Commons.
Yes.
And the part of the statement that particularly exercised him was, and I'll read it, first, though, let me deal with allegations that our armed forces operate so-called death squads in Afghanistan. This is simply, quote unquote, not true. That was the part of the statement that he felt he wanted to correct. That's from Hansard of the House of Commons.
He went on to observe our armed forces did conduct many daring operations to capture Taliban insurgents. However, these were not kill or capture operations. Rather, they were carefully planned capture operations with the object of capturing known Taliban insurgents and their associates.
But the specific bit he had spoken to me about was this bit. The whole thing is as is. I mean, I think what I would say was the difficulty in correcting that is this. We didn't also have any evidence to the contrary. that we were running death squads. And first of all, I don't agree with the language that was put as the allegation that the UK was somehow loading up death squads to go and do these things. So first of all, that. But also, it's a very difficult language to correct, because the alternative is, it is true. And we don't have any evidence to substantiate this allegation. As yet, we may find some, as I've always said, there may be some, there may not be any. So that's the difficulty with that statement in language, that I couldn't see, when he asked me my advice, a personal view was, okay, you stand up and you say, I misled the House, it was true. And then somebody stands up and says, well, where's the evidence? And the answer is, at the moment, we don't have any evidence. It's not the language I would have used in a statement if it was me, because we always believe all these things are open. I would have said something like, there's simply no evidence as yet to substantiate such allegations. However, if any new evidence comes to light, we will, of course, investigate it, which also matches some of the public statements we'd previously made. But that was the bit that Johnny found difficult and wanted to correct. But as I've explained, when you use that phrase, not true, it's quite a difficult phrase to correct without saying it. I mean, the opposite is true.
In terms of any advice that you offered him as the Secretary of State, did you seek to explain to him your view as to whether it was or was not a misleading statement, or did you?
Yes, I did. No, I did. I mean, he had his officials' advice, and I haven't read the advice from the officials to him about why it wasn't needed to be corrected, and I think that'll be a matter for that submission. I haven't read that, but I gave him my experience. And, first of all, every Secretary of State is absolutely, or minister, responsible for the statement they make in the House of Commons. You can't just read out a script. The system tries to give you a script, but you have to absolutely, it's you at the dispatch box, it's your person, your name, your reputation. You must satisfy yourself that these are the right words crafted for you. Now, I don't know whether this was in a script, as in he was reading from a written statement, or whether this was him in response to a challenge and he used those words himself. But ultimately, ministers are responsible for what they say into Parliament, nobody else.
Rather than a minister saying definitively the position is X, a minister could say, we don't know either way at the moment. That's an alternative, isn't it?
That would have been, I would have said, sir, something along those lines. Or, I don't agree, there is no evidence to substantiate this allegation at the moment. However, we are always open to new evidence, and if so, we will investigate it. Because at that very moment, we hadn't had a police charge, we hadn't had, we'd been through all those processes, and this was in the January of 2020. So I wouldn't have used those words in that way. Because, a minister, and especially in this environment, you need to leave yourself space should something new come to light.
Do you recall now whether or not Mr. Mercer had told you that he had had conversations with the Director of Special Forces?
He had been to see him as part of, earlier on, back in his initial meetings with me, getting to the bottom of, when I'd said he has my authority to try and get to the bottom of this. Yes, he had been to see him.
He expressed the view in his evidence to the inquiry that he did not believe what he was told by the DSF. Did he convey that sense to you when he discussed with you what had transpired in that meeting or meetings?
He specifically was concerned that he wasn't being told the truth about the full motion video.
And we will come on to that in a moment.
But that was the bit from his meeting with DSF that he had raised with me.
Right. There's another issue that I'd like to ask you about that relates directly to Johnny Mercer in this meeting, but can I just, since we're there, can we look together at paragraph 18 first of all, and then I'll return to Mr. Mercer. Paragraph 18. The Secretary of State spoke briefly on the link to the bill, expressing disappointment in having to concede on the timeliness grounds leg of the JR, just as a bill is going through Parliament which seeks to apply a time limit on bringing prosecutions. And does that accurately set out, at least in summary, the concern that you raised in this meeting?
Yes, I mean, you can imagine we were introducing a bill to try and prevent vexatious and prosecutions against our military personnel. And, you know, from the drafting and the creation of that bill, this comes along and it shows us both in a poor light, and indeed it makes some of the issues obviously harder politically to move in Parliament. However, what I would say, the bill does not bar prosecution, and it never did. It was a presumption, it was not a bar on prosecution. And so that bill is not as reported. There was always space in that bill for a prosecution if evidence comes to light. It's just that there was a limit that extended, and after a certain time limit there was a presumption. But also some of the offences that we are dealing with actually are beyond the 10-year point. So the bill originally was going to have 10-year, and then it became a 5-year point of prosecution, a presumption, but some of the earlier Northmores were before 10 years anyhow. So whether it was 10 years or 5 years, it wouldn't have made a difference. It would still been outside that scope. But it was a presumption, it wasn't a bar.
But it's perhaps obvious that it might look unfortunate at the time that you are seeking to introduce this piece of legislation, if it transpires, that the service police and the service justice system have not grappled with something in a timely manner.
It might have done, but this bill didn't circumvent ECHR and the obligations under Article 2. So people would have still had the protection of ECHR, victims and hopefully even the accused of the ECHR, the process. So the bill wouldn't have negotiated that. And I think the other thing that's quite important to recognise is that the Act is enacted in April 2021, and even the original bill as introduced covered exemptions from its own bill, including under the International Criminal Court Act 2001. There were exemptions. Those exemptions were broadened out in the passage of the bill, but nonetheless, some of the very crimes that are being discussed here would not have been covered by the bill.
Yes, Part 2 of the Act specifically excludes war crimes.
War crimes, and there are other parts of that bill. It's quite a broad, and sexual offences and everything else, it's quite a broad remit, but also it was a presumption, not a bar anyhow. So even if it included everything, it didn't mean that you couldn't prosecute someone for an offence.
Before then we leave this particular meeting, can I just return to Mr. Mercer for a moment and to an issue that he raised in evidence but doesn't appear in this particular note, and it is this. He told the inquiry when he gave evidence that he knew nothing about the allegedly withheld documents until they appeared in the national newspaper. Now, what I'd like to do, please, is to have your help with your 12th exhibit behind our divider 12. And if we look, please, to what is page 59, that will be page 3 behind divider 12. A submission sent on the 19th of March of 2020, so a few months before the article was published. Addressed to Johnny Mercer from Ben Sanders at DGEP, headed Afghan Litigation Update. And it provides as its issue update on judicial reviews of the RMP investigations into 2 incidents of alleged unlawful killing. And if we then run our finger down the page, please, Sir Ben, to the bottom of page 59 into paragraph 6. Council have started reviewing the information for relevance and to inform a future decision as to whether to apply for a closed material procedure in this case. They have brought to our attention, overleaf, several internal emails and other documents that contradict the position we took in the 4th of March permission hearing when we argued that as specific allegations in relation to this operation were not raised until 2014, the investigation had commenced promptly. And I pause simply to observe that 2014 was the date when the PMA instigated Operation Northmore, but as we've touched upon already and as you have told us, allegations were circulating within UKSF and wider circles as to the allegations of EJK at a much earlier stage. But going back to where we were here, If we continue with paragraph 6, in particular, one email records a meeting between the officer commanding the unit and the commanding officer of the Afghan partnering unit that took place only a few hours after the operation. At that meeting, the commanding officer made specific allegations that the 4 men had been unlawfully killed, stating that 2 had been shot while running away and 2 others had been assassinated. So just pausing for a moment, it would appear if this document had been read by Mr. Mercer, either on the 19th of March or certainly before the article appeared in the Sunday Times in August of that year, part of the background in the update from Ben Sanders included the reference to the fact that the position taken on the 4th of March could no longer be maintained, and specifically allegations in relation to not commencing a prompt investigation could not be resisted any further.
Yes.
Is this a document that at any stage you discussed with Mr. Mercer in the aftermath of the meeting on the 5th of August?
I can't recall that. What I can say is a submission like this, first of all, it's very serious, and it gives an early warning of what potentially is coming out from the now discovered document, I think is the way I would put it. And I think you'd have to ask Ben Sanders, and in much extent you're allowed to, the legal team, about how much of this was discovery, that they knew all along, that these had been there in their possession all along, or they had only just discovered them subsequently. And I think that goes to the difference between whether it was in any way a deliberate attempt to obfuscate, or was it in fact amongst thousands and thousands of documents just not reviewed or discovered properly. And that is a very common thing in legacy investigations, having done, I think there are 30 public inquiries in Northern Ireland relating to that. Some of those go back to the 1970s. So what I would say is it is open, when you read that submission, for any minister who received that to ask further questions. And it is always the case, because this hasn't changed, that actually if you really want to get to the bottom of a submission, it's not the one under the recommendation. You have to read into your submission. That's where you find the questions to ask. And so that, with my authority from the first meeting, Johnny Mercer would have been able to, if he'd wished, to have spent time or seen or whatever those documented who looked at.
If one reads on in the submission and one looks to the last page, that's page 61, and to paragraph 14, please, do we see that Ben Sanders identified a note of possible caution that the reader ought to be alive to?
Yes.
At this stage, it would be premature to speculate about the outcome of the judicial reviews, but it is probable that the court will criticise the unit and or the chain of command for not notifying the RMP of these incidents.
Yeah.
If you had read that note of caution being provided by DGEP, what do you think you might have done, Sir Ben, please?
Well, I am noticed that it's copied to my private office, but I don't think there's any... I mean, I was aware by that stage that we'd discovered some documents, and as I said, that was about the time that Ben Sanders got put to task. Ben Sanders is probably, he was an incredibly good official and diligent in his duties, and I usually took everything, well, always took what he said seriously. So, I mean, look, I think by that stage, you didn't even need to look at the documents to know, if you look at your paragraph 6, that things were deeply awry, and that people had not followed Section 113 of the Armed Forces Act in his paragraph 7, which notes that the obligation of a commanding officer to make a report.
Yes.
And just for the inquiry, unless you didn't know, the officer commanding the unit, I'm speculating because it's so close to the operation, it's the sub-unit commander.
Thank you.
And the commanding officer of the Afghan is obviously the Afghani commanding officer. So that would be the sub-unit commander of the British unit, as opposed to the commanding officer. that would be, usually we use OC to mean a subunit and a CO to mean a command officer.
Thank you. Do you recall whether between receipt of this document and the meeting on the 5th of August, whether you discussed the possibility of criticisms being made of the chain of command with Johnny Mercer?
No, I mean, I think by this stage, by the 19th of March, and the work Ben Sanders had been doing, it was very clear that everyone was going to be criticised, and rightly so. I don't think there was anything. You know, we were going to concede, obviously, to the court that because I think it was in these bundle of documents that I, for example, read the wider speculation stroke rumour by members of the SF community around these events. And I think that alone would have suggested that you can't maintain that defence. And that was just me as an amateur looking at those and thinking, it's not what it was.
And is that why you directed that there needs to be a thorough review of every single piece of documentation?
Yes.
In terms of further complaints that were set out by Mr. Mercer and giving you an opportunity to deal with them, please, can we have your help with Divider 13, page 63, which is an undated document that Mr. Mercer told the inquiry had been sent, if not to you, at least to your private office.
Yeah.
Undated, but it may be that from the first two lines we can put it within the chronology. I wanted to write and repeat formally my long-held concerns regarding the latest dump of emails in the Sunday Times this past weekend surrounding detention operations involving UKSF-1 in 2011. So it may or may not be that this is a document that was sent shortly after the article that appeared in the 2nd of August in the Sunday Times.
Yeah.
Can we just look with your help, please, if we count down?
I mean, he says this was about the time of the August meeting, and I don't have any reason to doubt it.
If we look, please, to the 5th paragraph, which begins that I.
Yeah.
That I have now been allowed to read out statements to the House of Commons that individuals in strategic appointments in the department knew to be incorrect is completely unacceptable. Do you remember discussing that view with him, that he had been allowed to read out statements, bless you, which individuals in strategic appointment knew to be incorrect?
I mean, the instance he raised with being unhappy what he had spoken to in the House of Commons was the one I read out. He didn't then refer to further statements he had made, and what I don't know is whether he was referring to parliamentary questions and answers in the normal defence question section of oral questions. Was he meaning when he gave answers there and they came from his notes prepared by civil servants, or was this specific to the statement? Reading this, I made the presumption when I first saw this recently that referring to his point about using the word simply not true in that statement. And again, it's like the question of being, all I can do is read between the lines when he says being allowed to read out, that suggests to me that he's answering from a pre-prepared pack that he has chosen to read out from. So it might be statistics, it might be, I don't know what I'm afraid you would have to ask him. But the area of concern for him the most to Parliament was the simply not true bit in the statement.
If we look on to the next paragraph, I would like to formally request in this letter to make a statement to the House in the first week of September correcting the record. Over and above this formal request, was any other request pressed by him in early September to correct what he had said in January of that year?
Well, he had made a request, which is why a submission was sent to him by his officials. I haven't seen that submission by officials, but he clearly had made a request, and the officials' advice was you don't need to or not required to, etc. He had raised, I think twice maybe, verbally with me the issue around the not true. And remember, that goes back to January 2020, so that was earlier in the year, around that position. So the only area I handled him with on that bit was the simply not true bit, to which the issue was really the language that had been used in the first place, and how do you correct that? But it was something that Johnny has always wanted to correct, and I think he tried to correct it even towards the end of the last election.
He regards in this document, and he did in the course of his evidence, that he had suffered reputational damage as a result of the position he'd been put in. Is that an expression that he conveyed to you when you and he discussed this?
Not really. I mean, Johnny was always worried about reputation in a whole range of fields. He took veterans' issues very seriously. He took his own military service very seriously, and so he should. And he was always careful to make sure that reputation was upheld, and didn't like people questioning that reputation any more than I like my reputation questioned. So he was always cautious around that. But look, I think on this, I suspect there were wider areas he felt that this made him and the department, or him and me, look silly in answering questions in the House if they had been inaccurate based on the new documents that were discovered in March onwards.
With the new documents that were discovered in March onwards, and the fact that allegations had been made at the time of wrongdoing by UKSF, did you seek to have any further conversations with Sir John Murphy or anyone else about the conclusions that were ultimately reached by Operation Northmoor?
No, because at this stage, my mind was turning to the fact that really the only real solution was a public inquiry.
Right.
Which, as you'll see from the documents, officials didn't want.
Well, we could look at that straight away if you'd like to. So, Ben, if we turn over to divider number 14, and to a document sent to you by the Permanent Secretary, addressed to you as well as to Johnny Mercer, dated the 26th of August of 2020.
Yeah.
As you'll see from the enclosed pack, a great deal of work has been done to follow up on your extensive discussion on the 5th of August of the Afghanistan allegations and associated legal process and options. If we look, we can see I and the team are acutely aware of the political challenges ahead, especially in handling the Overseas Operations Bill, which I'm clear is one of the department's very top priorities.
Yeah.
The independent assurance provided by Sir John Murphy and Mark Ellison, Queen's Counsel, may help to persuade the court that a fresh criminal investigation, even if a suitable and willing force could be identified, would be nugatory. And then, fourth paragraph, I believe that we should also continue to resist commissioning a public inquiry, which would be expensive, unproductive, and extremely bad for the reputation of defence and for armed forces morale, particularly if, as seems likely, a succession of witnesses were unable to recall their part in events on the ground. Can I ask you this, please, having dealt with the introductions in paragraphs 1, 2 and 3, when it came to paragraph 4 and the view that the department should continue to resist commissioning a public inquiry, did you agree with that, Sir Ben?
I think I questioned it. I would start proposing a public inquiry. I would say, why not a public inquiry? Fairly early on, actually. I think even before this, because I don't have anything to fear for public inquiries. I know taxpayers and departments don't like paying for them, so sorry about that. But ultimately, I wanted to get to the bottom of this. I wanted it over. I wanted our military to stop having to have every few months newspaper articles and reputation damage, and it was way before my time. I didn't have anything to fear from taking this through. Now, what I don't know, and it will be in the LPP, I'm afraid, was the legal advice I got around JR versus public inquiry, and whether or not one was a better legal route than the other, or whether the legal advice was that the JR is best to run its course. And I think those were the two areas that we were really getting towards by the time we got to 2020 and these revelations. And, you know, of course, as we saw, once we conceded in the JR, roughly about September 2020, and, you know, I think I used to read some of the comments by the judge, it became particularly clear that you know, we could cling on fighting JRs at some stage. But I can't remember whether I then wrote something on the 26th of August in a submission or a box note, but fundamentally my mind was moving towards that we needed a public, we need to get this over with. And the problem is in government, it's not a problem, but ultimately when you want to go there, you have to get permission from the Cabinet Office, you have to get permission from the Ministry of Justice. It then becomes a much more wider enterprise.
Leaving aside the concerns that may or may not be right about the expensive procedure of a public inquiry, could I ask you this? Did you share the Permanent Secretary's view that a public inquiry might be unproductive?
No.
And did you share his view that it might be extremely bad for the reputation of defence and for armed forces morale?
Not really, no.
Did you challenge him on the view that he offered in the advice provided in paragraph 4?
Well, I think, I took on board his view, and I think we wanted to see how the JRs progressed. But ultimately, I think the fact he had raised it in his email was because we were talking about it.
Insofar as this email provided any advice on the position that Johnny Mercer had said he found himself in, namely that he had misled the House in his statement in January, can we look to the bottom of the next page, page 66, paragraph 10, and the last two lines, on the important issue of whether Parliament was in any way misled, which officials do not believe to be the case.
Yeah, and that's the 68, isn't it? Page 68.
It is, yes. If we then look on to page 68, 21st of August, the advice provided by DGEP sent to the Secretary of State via the MIN-DPV, so received by you and by Johnny Mercer. We see under the recommendations section, paragraph 3, Roman 2, nothing in the recently disclosed material changes the position as set out in Mr. Mercer's speech during the 7th of January adjournment debate. There is no requirement to correct the record at this stage. And did you agree with that conclusion that had been reached by DGEP and provided both to you and to Johnny Mercer in late August 2020?
Hang on. Which paragraph are you on, sorry?
Recommendations section,
right, okay.
number 3, Roman 2.
Well, I agreed insofar as, yes, I did, because of the statement of 7th of January, as I've said, it's simply not true. The allegations or the new documentation certainly revealed that we had been untimely and that we conceded that. It still, as yet, didn't produce, I think, the evidence. What we hadn't then seen from these new documents was whether the military police would either reinvestigate or indeed come to a new position from their original one. So I think it was still open whether it would have led to any type of prosecution or that there was evidence in these reports or these new documents that went further. Many of the documents I read were not. They were people not there, people emailing amongst themselves, I think, whereas there was one or two documents, namely the one about the subunit commander and the commanding officer of the Afghan unit that I think was of concern. So I think I would have said, I would refer you from number 2 to number 4. I think 3 is missing from that. Recommendation, I think it's 1, 2, 4, is that as directed by Affairs, we have started to read the totality of the evidence collected by the RMP in relation to these incidents. If once this is completed, the position is no longer tenable, we advise at that point. So I would be waiting for I'm afraid it took time, but for that part to come back to us. So if it then turned out there were more evidence to produce that showed we were, operated so-called death squads, then of course that would become untenable if the evidence came to light. And Johnny would be absolutely right in trying to correct that. But at the time he gave that statement, the facts before him, where the case sat, he was able to say, I'm not quite sure I'd have used those language, but he was able to rebut the allegations as put. But he didn't leave himself any space, which I think is a difficult issue.
Well, if Mr. Mercer's evidence to the inquiry is correct, he was armed with rumours that he had been made aware of from within the SF community about innocents being killed on target, or about those who were not posing a threat being engaged and killed. He was aware of complaints made within the Afghan partnering unit, which in his words had confirmed his worst fears. And also, he was alive to an assertion by a serving individual that that person had been asked to carry a dropped weapon. Mm-hmm. So if one considers the combination of those three things, rumours that people have been effectively murdered on target, together with the Afghan partnering unit confirming his worst fears, and direct evidence that somebody had been asked to carry a dropped weapon, when he came to assert, as he did, that the UK forces were not deliberately carrying out extrajudicial killings rather than attempting to capture Afghan males, do you regard that observation to the House in January of 2020 as sitting well alongside the information he told the inquiry he was privy to?
The last point of the three, that he had actually directly met someone, is the point of evidence throughout this process that he was not alone in being aware of rumours. Okay, so your first point was well trodden by January 2020, and indeed the police investigation that in the end those rumours led to in 2014, a police investigation, had in theory been tested, investigated, and then assured by Chief Constable Murphy. So on the first point, none of this sits pretty in any of it, but the solid bit, the bit about meeting a person who'd asked to carry a dropped weapon, the first I read about it, and the first that many of us read about it, was in his statement to this inquiry. It doesn't mean to say it doesn't happen, and I know this inquiry has been very interested in that statement. But it was, if half of this, or more than half of this whole process has been to try and find some evidence to get to the bottom of it, then all along the one person in possession potentially of evidence has been the minister. And I think that's important to find out. And I don't know. However, what I do know, and maybe there is a confusion in the witness or the evidence, that Johnny had met people who'd met people who had talked about what was going on. So he'd met, or he'd heard, like the then commander of that unit, he had heard rumour and he had heard discussions. No different from N. What's that? I'm going to get this right.
1785.
N1785, and that may well be that was the same position. But the actual, I mean, again, I don't want to end up in being amateur Agatha Christie. Fundamentally, the one thing that stood out to me was there was an actual person who actually had been asked to be part of a conspiracy, if that statement was true. And that, to me, is incredibly important. But that only came to light in that statement to this inquiry.
Can we look next to the email that Mr. Mercer sent to you on the 2nd of September following the advice that we've just considered? That is your divider number 15, our page 72. Do you see it? It begins at the bottom third of the page, an email dated the 2nd of September at 10:50 in the morning.
Yeah, this is to his private secretary, correct?
Yes, and for the attention of the Secretary of State and the Permanent Secretary. If we looks to the last two lines, on misleading the House, I do not accept the advice from the department. The whole episode has seriously shaken my confidence in their work. Was it still open even at the 2nd of September for Mr. Mercer, had he wanted to correct what he'd said back in January of that year?
Well, I think we still go back to the problem of how do you correct it back in January? I mean, how do you correct it's simply not true? He could have gone, does he come back and say it's simply true? And I don't think at that time, and still there is not, and maybe this inquiry will find that, there was substantive evidence to say that was true.
Well, insofar as one of the specific complaints that he had about what he'd said was, he'd asserted that a very small number of people had made allegations, and he now was of the view that that was inaccurate. If we look at the top of page 73, he wrote on, it's now clear that a significant number of people had raised concerns, including senior officers within UKSF.
So there is a difference between correcting the record, like going back and saying, I inadvertently misled the House. Mr. Speaker, I want to correct the record. If at the time you made the statement, it was known to be untrue. If after you made the statement, it is then subsequently found to be untrue, you are able as a Member of Parliament to correct the record in a different way, insofar as a parliamentary question, in a debate, in a open questions where you can say, if you wish, that information has come to light and what I said at the time was therefore incorrect. So it's not, I'm afraid, quite the same thing as I deliberately misled the House and I apologise. It is effectively, at the time he made the statement, I think he believed it to be true, and especially that point about a small number of people, and it is open, I think, in that sense. But that was not the bit he raised with me. He raised the bit about the simply not true.
And again, he identifies within that document, if we look to the next substantive paragraph down, beginning my view remains as it was in August. I would not be content to progress on the course of the Overseas Bill without me giving a statement to the House dealing with all this. Quite apart from the department looking poor, which I see is generally accepted, my own credibility looks ridiculous on the subject, arguing for a 5-year time bar while this stuff continues to drip out. Again, in any way, did you share his concern that information was dripping out and that made the Overseas Operations Bill difficult to argue in favour of?
I understand Johnny's concern. I think my point was, because by that stage the Overseas Bill was exempting all of war crimes and all of a very large part, and was not a bar to prosecution but a presumption, it was very, very unlikely, if not impossible, that any of these cases we're discussing today would have been covered by the Overseas Bill.
When did the carve-out under Schedule 2 to the bill start to be proposed?
Well, the bill did produce on introduction a carve-out in Schedule 2. The width of that widened through the process of the bill, and I would need to check out. It's only become an issue raised with me on Friday or Thursday by the media. But obviously the act that is delivered is the responsibility of me as a Secretary of State. And I've introduced 7 or 8 bills in my time, and they all start and end differently. So I don't know when, but the initial bill as introduced to the House did have a carve-out for certain offences under both the International Criminal Court Act and Geneva Conventions, effectively, and some other offences as well. And then that got widened in the process. But it started with a recognition, because otherwise the bill would not have been in compliance with our international obligations.
At any stage, was it envisaged by you that the bill, when passed, would provide a blanket exclusion in any way to the prosecution of war crimes?
No, because it was a bill of presumption, not bar. So it could never have done that.
Can we deal with another of Mr. Mercer's particular issues? And I've tried to do it chronologically in the hope that it makes it easier for you. I anticipate that the question about FMV or full motion video was one that was raised by Mr. Mercer on any number of occasions. Is that correct?
I think he raised it twice or three times with me, yeah.
And in particular, it was something that he raised with you after he'd had a meeting with the DSF.
Yes.
And he did not accept that what he'd been told was correct.
But I think what his statement alludes to on the full motion video is he wasn't always aware of what I was doing to test the veracity of all of this. So in his statement, he sort of alludes to the fact that no one took that up. What he didn't know was I didn't take it at face value, and in my evidence shows I wanted to know in writing from the United States authorities that they did not have in their possession the full motion video. And therein lies an example of the slight fine line between policing and not. But Johnny had raised that on a number of occasions, and I felt it was very important that we checked the veracity that I was being told of this information. And I know another, only because I read it in the media, that another data source that had been told was not available, this inquiry now has access to, that had been told wasn't available to anyone and had been scrubbed. I know that this inquiry has now got access to. I haven't seen it myself. But on full motion video, like I said, in most of these submissions, I don't take it at face value. And we got a confirmation from the United States in writing that they did not have possession of it.
Mr. Mercer's evidence on this particular topic, he told the inquiry that his recollection was he'd said to you that something stinks in respect of the claim that there was no full motion video. Do you remember if that was the way he described it?
All similar, yes.
And his recollection of what you had said to him was that the issue had been thoroughly investigated and there was no new evidence. Again, do you remember whether that is what you said to him or not?
Well, I eventually, after having written assurances from the United States on that, I would have communicated that to him. What I don't know is when he makes that allegation, if it was actually while I was busy checking out in the United States, because that would not have been the case until I had received written assurance from the United States.
In which case, can we look briefly, Sir Ben, at the written assurance you received? You'll find that in divider number 9, our page 36. We have here a document dated the 23rd of June 2021, which is why I've taken it after the other documents that I've just asked you about. We have a note in handwriting at the bottom under the section Secretary of State's comments. Can I ask you this? Is that your handwriting?
Yes, it is me.
And what you had written was storage of ISR data, that's intelligence, surveillance and reconnaissance data. I want to see written confirmation, the US brackets from the US, that they do not have the ISR available / stored. If they do, I want to formally request it. So do we understand from that note in June of 2021 that either you wanted access to the full motion video if it existed, or you wanted written confirmation from the US that they did not have such evidence available?
Yes, I mean, I didn't want to personally view it, but on behalf of the department. And Mr. Glasgow, it sums up everything I've been trying to say today, which is I don't take at face value what I was told. I went beyond just ticking off a submission, and in fact, in this example, for example, I didn't even trust my own source. I wanted it from a third party, and if the United States told it to me, then that was something that I would have accepted.
And as to how that observation in writing by you then played out within the department, can we look, please, with your help to divider number 10? And within that section, if you can look, please, to page 38. In fact, no, sorry, to page 41. I do apologise. That would be the fifth page in this particular section. So our page 41. And the bottom half of the page contains an email dated the 28th of June.
Yeah.
2021, so a few days after the handwritten note that you had applied to the earlier document. If we look to the main paragraph of that email at the bottom of the page, Secretary of State has asked for written confirmation from the US that they do not have the ISR available stored. If they do have it, Secretary of State would like to formally request it. So we see here that your Assistant Private Secretary has put into effect the official request by you that the United States be spoken to and contacted about this particular subject. If we then, as we always do with emails, if we can just read backwards, going up the page and then back to the pages before, we can see how the request is sent out by the Assistant Head of Litigation Policy for Historical Overseas Operations, have reached out to the RMP to see if this was requested as part of the investigative phase. Happy to keep you in the loop. And then back onto page 40, if you wouldn't mind, Sir Ben.
Yeah.
You'll see a little later that same day, still the 28th of June, the bottom half of our page 40. If we have not got formal confirmation that it does not exist, then a letter will need to be drafted to Secretary of State to send. Please can we look to get a response as soon as possible, noting potential follow-up actions that may be required. And then the reply to that starts, in fact, at the bottom of the page before. So if one looks first to the bottom of page 39, there is an email dated the 29th of June and timed at 11:28. And you'll see the last two lines on the page 39. Regarding the request for ISR, I've been in touch with the SIO regarding the Afghan JRs. He has come back to me this morning. And then the reply is copied in at the top of our page 40. In September 2017, through the appropriate channels, he requested that searches were conducted of the US systems for any full-motion video for all 11 operations that they were scoping. He provided dates and air platforms for them to focus the search perimeters. They pursued this request through different government agencies and embassy liaison officers. In November 18, a formal response for the US authorities through the liaison officer was received, stating that searches had been conducted and they could not find any full-motion video for those dates and times. I hope that this helps allay the Secretary of State's concerns that this avenue has been exhausted. And then, completing the exchange of the emails, if you wouldn't mind, please, Sir Ben, turning back to page 38 to the email sent on the 5th of July, timed at 17:25. Regarding the Secretary of State's requesting FMV, we've done quite a bit of background work on the request for the formal response from the US, stating they do not have any FMV of the incidents in question. The attached document is the signed statement the investigator received via the liaison officers. This was stored away in the investigation archives. This is the document that closed off that line of inquiry. And if you keep one finger in page 38 for a moment, and then turn on in the divider, if you wouldn't mind, please, to page 46, which is the front page of a service police witness statement. It's a statement provided by a United States nominal US N116, and it records that this individual has oversight of recorded FMV footage which covers ISAF operations in Afghanistan. It's a statement dated the 19th of November 2018. He sets out the request made of him, and then one has the date, time grid, locations and airframes for the 11 particular operations that was the subject of Operation Northmore investigations. If one looks to the last page, our page 48, USN 116 records I conducted checks on the relevant systems and established the department have no FMV footage stored in any format pertaining British forces covering the above search criteria. That was provided to you, and if we then go back to where we were on page 38, and I apologise for jumping round in the sequence, but then the last of the emails in this chain is dated the 13th of July 2021, timed at 9:45 in the morning, with thanks for the below and attached, which the Secretary of State has noted. The Secretary of State is content there is no further action given. We have no formal response. Now, those inquiries that have been conducted by the RMP with the United States authorities appear to have been signed off in effect in November of 2018.
Yeah.
Can I ask you this, please, Sir Ben? In addition to those inquiries, did you ask for or instigate any inquiries with the United Kingdom or with the DSF to see whether there was any available stored footage on any other platform?
No, but I was informed that by Johnny Mercer, actually, that the platforms that would have had the area he was least convinced by in his discussion with the DSF was the full motion video bit. That is the area I sought to request the footage, and it's the broader ISR, as it says. And while this statement was February 2018, or whatever it was, November 2018. I was happy to accept that as it came from a US citizen and personnel, and while it wasn't a new one, as my original note had said, I accepted that was a true and fair statement that gave me confidence. It was, it would have been, this individual was out with the UK Special Forces community, wasn't affected or part of it, wasn't part of the Ministry of Defence, and therefore I was happy to take that at the face value it had. As far as what else I sought, again, I would have left that to the experts who knew what other data records are kept of those operations. I was not in Afghanistan and therefore was not aware. And often I would take Johnny Mercer's advice about those operations as he knew how those operations were conducted.
Do you recall whether this was any of the matters that you raised with Sir John Murphy when you sought assurance from him about the quality of the investigation that had been conducted by the RMP? I
think I did include FMV. I can't be certain because I don't have any notes, but I think I did. It was all part of... the main standouts are the early reporting in 2011 between the commanding of the unit and indeed the DSF, and why it wasn't referred to the Armed Forces Act, and then the issue of things like the ISR and overhead and FMV and whether that was in fact available, because that would be very illuminating if it was the case. And so I sought to establish those independently, effectively, of the rest of the assurances.
Can I conclude the chronology, please, with your help, Sir Ben, to deal with another of your exhibits? And can I invite you to turn, please, to divider number 7, our page 31. And this takes us to the summer of 2022 and to a letter that was sent on your behalf to the BBC and indeed to the Panorama production team. You wrote that you were writing in response to their letter of July 2022. Our armed forces serve with courage and professionalism in Afghanistan, and we will always hold them to the highest standards. Military operations are conducted in accordance with UK and international law, including the law of armed conflict. Any criminal allegations are considered and investigated as appropriate. As you are aware, the Royal Military Police is conducting a review to consider media allegations of unlawful killings by British forces in Afghanistan. I'm aware that the RMP has written to you to request that any information in your possession that may amount to new evidence be provided to them to enable them to review it. Further, they've assured you that any review and or investigation by them would be independent, effective and accountable. I understand that you're in dialogue with the RMP. Given the seriousness of the allegations made by the BBC, I would hope that any information that may amount to new evidence can be provided in a way which conforms to your editorial guidelines. Finally, I would reiterate that we believe that the allegations referred to in your last programme about UK forces have already been fully investigated by the service police. I would also note that its use of Australian material seemed deliberately confusing for the uninformed viewer. Can I ask you this, please, Sir Ben? The RMP's review to consider media allegations of unlawful killings, what part, in any, did you play in that particular review?
I didn't play a part in the review of the military police and their investigation.
Did you instigate such a review?
Well, I instigated insofar as, if you notice on my earlier statements, that please pass any more, if there is any evidence, and they will review it, and in a sense clearly stated in those public responses that the military police would investigate. The idea of I mean, I didn't send a letter or anything saying there's a formal review. It's not for me to do so, but military police were in contact at that stage with the BBC, so I think they were obviously, should have been, and hopefully reviewing any evidence the BBC had given them or anybody else.
And was it your understanding that the RMP were at that stage at least engaged in a review to consider any fresh allegations that had been raised in the media?
It was, I wouldn't have called it a review. I suppose it was a review. They were examining, as I had requested in previous submissions, what was being shown in the media and telly, and whether there was any more cases to answer. And indeed, I would not have been aware of any evidence that the BBC had shared in its previous documentaries or the Sunday Times, because I would not have been, the separation between me and the police investigation would have been paramount. So for all I knew, they were looking at something else or not. I mean, I wouldn't have known.
When you invited them to provide any new evidence in a way which conforms to your editorial guidelines, what were you hoping to achieve by that?
Well, that they, like everyone else, if it wants to get to the bottom of this, should share whatever evidence they have to help us get to the bottom of this. I mean, one of my concerns throughout is no one seems to have wanted to provide evidence to anyone, not the media, not some of the witnesses, and this is why we are here now in an inquiry. And I don't really care who it is who is offering up evidence, but to me, in my, if you prove in my sort of humble view, the right place for new evidence is with investigators, people legally empowered to investigate and enforce the law, or indeed prosecute the law. That is my view. That was my view to the journalist who rang me last week about asking me to respond about the overseas bill. That the right place to put those questions is to me and my colleagues in this room. That's how we will get to the bottom of something, and maybe if there is evidence, we will find the true evidence that leads to a conviction if that is what is recommended.
And do you regard that as a duty that applies to anyone that's got relevant evidence to give?
Yes, I absolutely do.
And recognising what you'd said very early on about the need to proceed on evidence rather than rumour, do you recognise the importance that there is for anyone with relevant evidence to come forward to this inquiry to assist the chair with his examination of the issues in hand?
Yes. And
presumably that is a duty that you would encourage anyone in or out of uniform to adhere to.
Yes, look, absolutely. I mean, there's no ifs or buts. That is the duty that they have, and you must come forward. And if you don't, you let down your colleagues.
And you let down your colleagues.
And your country. So,
and that's what I was going to come to, Sir Ben.
yeah. I mean, look, we are dealing with a very, very serious issue. We are dealing with, however, men mainly, but men and women who risk their lives to keep us safe. And if this inquiry finds new evidence that leads to someone being convicted, then those people have let down their colleagues and their countrymen and the country, and they have broken what we stand for. If, however, this inquiry finds no sufficient evidence, then we all also bear a responsibility for our handling and how that has damaged their reputation as well. It's not an easy or enviable task you have, sir, in that tightrope, because I have also seen veterans taken to court where convictions have failed because ultimately they didn't reach the criminal level. And we all saw that in Northern Ireland. We also saw some convictions. So it is a very difficult and heavy responsibility that this inquiry now has. But ultimately, we are better than our enemy because we do not do that.
So Ben, thank you for your assistance today in answering all the questions that I've posed. I appreciate that you have just had an opportunity to speak directly to the chair, but if there is, as I said at the outset, anything that I've not covered, or if there's anything that you would wish to assist by way of further evidence, this is not the only opportunity to give him, but if there's anything you would like to say, we would welcome it now. And again, in due course, if there's anything else in the future you can assist us with, either we'd like you to volunteer it or we will ask for it, sir.
I will, what I will do, if I may, sir, is provide you with the clarity around the overseas bill, as it has only been really raised with this inquiry and myself at short notice. I think providing you as a start point with the clarity of when decisions were made and how, so that people understand what it was about, that may be helpful to the inquiry as well. I mean, ultimately, as I've said, that the bill is, when it became an act, is my responsibility as Secretary of State. That is entirely my responsibility, and so I will be happy to answer those questions. We'll probably do it in writing, and if you wish to see me, I'm available.
Grateful. Thank you very much. Thank you, sir.
Thank you, Mr. Glasgow. Sir Ben, just one short point. Can you remind us who the permanent secretary was who wrote the memo at tab 14 in August 2020?
August 2020, I think, was Sir Stephen Lovegrove.
Sir Ben, thank you very much for coming to give your evidence to the inquiry today and for the obvious care and hard work that you put into studying the documents and giving your answers. It's been a long day, but I'm pleased, and I'm sure you are, Mr. Glasgow, that we've completed your evidence today. We'd reserve tomorrow, but I wish you well tomorrow. We will now adjourn, please, and there will be further directions from the inquiry in due course as to the next open hearings. Can I thank everybody today for their careful attention to the evidence, and thank all the court staff, including in the Royal Courts of Justice, and my team for the very careful preparations for this hearing. Thank you very much indeed.